Welcome to Off the Record, a legal podcast.
Hello and welcome to Off the Record, a legal podcast with attorney Rhett Burney. My name is Kevin Rosenquist, and we're talking today about a topic that can affect many South Carolinians. Is that how you say it, Rhett? Is it Carolinians?
No, South Carolinians, but Kevin, I'll give you a break.
All right. Thank you. I appreciate that. Well, we're going to talk about some of the reasons that divorce and custody court cases are expensive. Rhett, welcome. Good to have you back.
Good to see you, Kevin. Are you a Coloradian or a Coloradian?
Coloradan.
Okay.
Coloradan is what they say. Yeah. So let's start talking about these. So let's start with one here. We went over some of these before. You talk about attorney time and expertise. Why is that? Does that become expensive?
Yeah, one of the biggest complaints that we hear from clients, just divorces and custody cases are so expensive. Well, it's because you have lawyers involved, and we are expensive because you're paying for our knowledge, our expertise, our experience, and of course you can go represent yourself in court if you want to for free, but probably not a good idea. So we spend lots of time working on cases to make sure they're prepared properly, and we have to charge for that. And one thing people don't understand is that we have support staff. We have copiers and computers and all of those things that we're paying for on the back end, but all that is designed to help cases move forward. And sometimes, depending upon the facts of a case, we have to hire experts. We may need parental alienation experts, custody experts, financial experts, and those people charge money as well. And lots of times when those people are needed, it's because for a particular purpose, and their testimony is crucial in court. And without them, we can't present your case, the client's case, appropriately.
And when it comes to things like court rules, procedures, does that affect kind of what you and your team have to do and when you have to do it?
Yeah, so that drives up cost as well. And it's because there are court rules that we have to follow as lawyers. We have rules of evidence. It's not just a free-for-all. It's not a wild west when you come into court. You can't just get up and tell your story. There's certain ways we have to do things. And that's lost a lot of times on people who have never been to court. They think it's very easy. You just get up there, you tell the judge your side of the story, and the judge makes a decision. But it's not that simple. We have to go through certain methods and certain procedures in order to present a case, put evidence in there, and to show what we want the court to see. And when we do that, it does make court cases take longer, but it is necessary in order to properly present a case.
Are there fees and costs associated with just court filings and things like that?
Yeah, anytime you file a case, there is a filing fee that the government charges you in order to do so. And those fees have gone up steadily over the years. You just cannot go to court, hand the clerk a document and not expect to pay for it. They do charge those fees. And there are, of course, administrative costs as well. You have postage. When we have to serve people with our court documents, our pleadings, we have to hire process servers. They charge fees. If you e-record documents, there are fees associated with that. And we get it. Clients get bills and they think that they're being charged for everything. But, we try to use transparent billing and we lay it out. You're being charged for this, and this, because we're having to pay that on your behalf, on the client's behalf. And in all lawyers' fee agreements, they pass that cost on to the client.
Sure. We hear about the term discovery in a lot of different situations, particularly in criminal defense and stuff like that. Is there discovery in these cases as well? And how does that affect the cost of a divorce?
Yeah, discovery is very expensive. And so let's talk a little bit about what it looks like. What is discovery? So when we're going through a case, we have to get all of the evidence that we need in order to present a case. As you can expect, people going through a divorce or people going through a custody battle, they don't see eye to eye. So they may not necessarily voluntarily hand over the information. So we have to ask for it. And with discovery, we don't necessarily know what we're going to find. So we have to be broad in our request. And it tends to produce a lot of documents that we as lawyers have to go through. And when we send out interrogatories, which are questions that need to be answered by the other side. They'll turn around and they'll send those to us, and we have to answer them. And every client gets them, and they wonder why they have to answer these questions. Well, one, the court rules allow it. And two, it helps the lawyers on both sides prepare their case in order to present it in front of the judge. Now, I'll tell you that most of the stuff that we get through discovery, we don't need. It's not going to change a case one way or the other, but it's one of those things where you don't know what you don't know. So we have to ask for a lot of information in order to see what information we get. Lawyers hate going through discovery. Clients hate going through discovery. It takes a lot of time. We're in the age now where it's very document intensive. A lot of digital evidence out there. It's getting more and more complicated. When we go to trial, I'm getting ready to trial one this coming Monday, and I bet we have 100 exhibits, bank statements and pictures and those types of things. And it takes a lot of time to get all of that together, because when we get that information, we may get 100 pages and we may only one page may be relevant.
Mm-hmm.
And so we have to still go through all those documents and sometimes piece the stories together. And unfortunately, clients don't like to see a lot of billing on the discovery side, because they wonder, what did I get out of it? Well, it helps us know what we're dealing with, and it also helps us prepare cases. Discovery is very important, but it can be very expensive sometimes.
Do you feel like people tend to think, oh, well, this is, outcome is obvious. This is easy. And then they're surprised when it takes longer and it's more complex?
Absolutely. Every time. Everybody comes into a case with their own perspective, thinking they have the strongest case and that the other side doesn't have a chance in the world. I've been doing this 30 years, and very rarely does someone come in and say, I've got the weakest case, just do what you can for me. That rarely happens. So unfortunately, judges don't see it like every side wants it to be seen, right? There can only be one winner in a case. A judge is going to pick a side to rule for, but it's not as clear cut as people think it is. And here's the other problem we deal with. Clients often ask us, what are my chances in court? What is the judge going to do? Well, we have the facts that we have to deal with. We have the law that we have to deal with. And then we have the judge that we have to deal with. And you can have 10 different judges and present 10 different set of facts, the same set of facts in front of those 10 different judges, and they can interpret the law differently, and they can look at the same facts differently and give different results. So it is so hard to get these cases prepared and to know what a judge is going to do. And so when you go to trial, that is costly. And so we oftentimes try to get clients to understand that it's better to work out a case, to settle a case. It saves a lot of money if they do so, because when you go in front of a judge, you really have no idea how the judge is going to hear the evidence that you presented or that you present. And it's not unusual for a client or a party to get a result and they not like the result and they blame it on the lawyer, when really it's not the lawyer who's made up the facts. We present the facts and the judge just doesn't agree with what we want them to agree. So, and that takes time and money to get in front of a judge.
And kind of piggybacking off that, you're also at the mercy of the opposing counsel. I mean, the opposing party, their actions are not always going to just completely align timeline wise with yours, I'd imagine.
Yeah, so it is inevitable in every case. Clients will come in and say, I can't understand why this is so difficult. Well, you're in a lawsuit. And if both of you saw eye to eye, you probably wouldn't be in a lawsuit.
Mm-hmm.
So the other side wants what they want. Our client wants what they want. And so they're fighting, and it just takes a lot of time to get parties to either to settle their case or to go to trial. And it is hard to get clients to understand that just because they want something, that doesn't mean they're going to get it. And it doesn't mean that they're going to get it when they want it. And, in order to get an answer to a problem that the people can't work out themselves, sometimes it necessitates a trial. That costs money. We hope to work these cases out in mediation, and that costs money as well. But it costs less money to go to mediation than a trial. But if you don't get your case worked out in mediation, you have to go to a trial.
What are contested hearings or contested trials, and do they affect costs as well?
Yeah, absolutely. They're the worst. Um,
Sorry to bring
other
up a sore
words,
subject.
yeah. Now, as lawyers, we have fun in the trials and fun in the hearings, but it takes a lot of money to prepare for those. We tell our clients for every 1 hour of presentation for a trial, it probably takes 3 hours of preparation on our end. So when we have a contested trial or contested hearing, that just means that the people can't agree on the issues between them, and they're asking a judge to make that determination. And in order to give the judge the information that he or she needs, you have to present your case. You have to present witnesses. You have to present testimony. You have to present evidence. And that just takes an enormous amount of time in the preparation, which is costly, and in the presentation, which is costly as well. Because lawyers, we bill by the hour. So the more time we have to spend on a case, the more expensive that case becomes. And believe it or not, as lawyers, we really, really, really would rather not spend our weekends preparing for a trial. We would rather our clients settle their case. But inevitably, even though we tell them that it will cost more money to go to trial, they don't listen to us, or they think they're right. And a lot of time they are, but not everybody can be right in the same case, right? Everybody's got different positions, and so that's what a judge is for. Or if it's a civil case with a car accident, that is what a jury is for, in order to hear all the facts, apply the facts to the law, and to make a determination or a judgment.
How common are delays in these situations?
Oh, yes. So delays are common in court. You have to remember that there are so many different things that have to work together to get to a particular point. For instance, for a mediation, you have to have all the lawyers' schedules meet up along with the mediator's schedules. And so it's very difficult just to get three people whose schedules all align at the same time, as busy as lawyers are with court hearings and such. There sometimes cases overrun into other cases, and that causes a delay. The court system's just backed up. There are only so many judges, only so many court days, and so it's not like going to the restaurant that you want to go to on that day you want to and when you want to. For a court hearing, you have to ask for it, and they're set weeks or months out. And if you want a trial, depending upon how long the trial is going to be, that's even further out, just because courts don't run 365 days a year. They don't run 24 hours a day. And there are so many court cases out there that the system's a very good system, but it can't handle the volume of the people that are asking the court to make determinations. So delays are quite common. Court system's not fast. Anybody that gets ready to be involved in a court system, they have to learn to be patient. If you cannot be patient, you will definitely hate being involved in litigation. If you can learn to be patient, it will go much smoother. Expect it not to happen quickly. Going to court or being involved in court cases is much like building a house. It will cost you twice as much as you expect it to, and it will take twice as long to do it. That's just the way it happens. There's so many different moving parts, and people don't understand because they don't do it every day. And I get that. They don't understand how complex these matters are. They look at it just from their side and they think this is a simple solution. What's the problem? Well, you have all these steps that you have to go through, and it takes time. So yes, court cases do not happen as quickly as we want it to, or as fast as clients want it to. And we've kind of gotten spoiled in this world, haven't we, Kevin? I can get on Amazon and order something and I can have it tomorrow. When I was younger, 4 to 6 weeks for ordering something by mail was regular. And as things have changed, we're all getting a little bit more spoiled, and we want things when we want it. I do too, but that's just not how it works in the court system. So yeah, delays cause problems in the court system, and it drives up cost.
Yeah, you bring up a good point about the instant gratification. I mean, we have that in so many different areas of our lives now, and it's just logic that it'll just seep into our expectations for other things as well.
Yeah, it does. It does. And unfortunately, the court system is not built like that. It just is not like that. You just don't show up one day and they fit you in. You have to have there's a schedule that's followed. A docket is what we call it. And you get put on the docket. Whenever they get to you, they get to you.
You mentioned earlier about how, people might, want to go to trial, even if it's not really in their best interest and it's going to add to the cost. Obviously, there's a lot of emotion at play here, especially in divorce cases. You're dealing with people that don't want to concede anything to the other one because there's maybe some bad blood or some stuff like that. How much does the infighting, does the emotional aspect of things affect the timeline and the cost of these cases?
It can make it nasty. It can make it nasty. People, when they dislike the other side, sometimes they lose all logic. And when you lose all logic and your emotions take over, you make very bad decisions usually, and those bad decisions cause consequences, and those consequences causes lawyers to get involved and to clean up the mess. And every divorce case will end, okay? Every custody case will end. There will be a final decision. And most of the time, the obvious answer is right in front of both parties. But because of the emotions involved, the pound of flesh mentality, they want this because they're hurt. They throw out all logic. They don't care about the cost. They don't care about the time. They don't care about the headache. They just want to get back at the other side, or they want to feel heard. And unfortunately, when you go in front of a judge, they don't have any emotions at all. They will hear the facts. They may sympathize for you, but their emotions are not going to sway their judgment most of the time because they're just applying the facts to the law and they come up with a decision. So when you get very high emotionally charged people involved in a case, it tends to make it nasty. The lawyers hate it. The paralegals hate it. The clients hate it.
Yeah, no one wins there.
Yeah, we try to talk them off the ledge, but inevitably, because they're hurt for whatever reason, right or wrong, that tends to take over their judgment, and that tends to cause lots and lots of problems.
To finish up here, I know there's something called post-judgment disputes. How common are these, and what exactly does that mean? Is that what it sounds like, where there's actually some fighting going on after the judgment?
Yes, believe it or not, just because you reach the end of your court case and you have an order signed by a judge, their decision, that does not solve all problems. Human beings are very creative in creating new and unusual problems. A judge will issue an order and it will be in writing, and the order is supposed to be a way to solve their problems. But as humans do, they find little loopholes and they find other ways to interpret these orders. And they don't see eye to eye and they don't follow the orders. And when you have people that are constantly not following orders or trying to find ways around orders or just being difficult, being hard to deal with, that causes more fighting. And we get calls from clients, the case is over, saying, hey, my ex-husband, my ex-wife, they're not following the court order. What do I do? And depending upon the severity of it, we may have to get involved, again, and that may bring a new case asking a judge to address some of these issues that have arisen after their order. And judges don't like that.
No, I'll bet. I would imagine.
Yeah.
Well, certainly nuanced and certainly great information. So hopefully that helps some people out there who might have a little bit of a misunderstanding about the timeline and the cost. Thank you for tuning into Off the Record, a legal podcast with attorney Rhett Burney. If you'd like some more information or you'd like to connect with Rhett, you can visit rhettburney.com. And don't forget to subscribe to our channel. Leave us a review. We really appreciate it. Rhett, it's always great chatting with you. Thanks so much for your time.
Take care, Kevin. Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.